Mr. Overholzer, that's your client, Mr. Nelson. Do you need a breakout room with him?
I do, Your Honor. Let me just confirm whether or not. One moment, Your Honor. Your Honor, just for the record, it looks like this matter was scheduled for a pretrial conference initially back on April 27th, 2021, Your Honor. This is set for a second pretrial conference today. During the first pretrial conference, the assistant prosecuting attorney indicated that this would require further negotiations until any offer was to be extended. At this point in time, Your Honor, no offer has still been extended on this case, and so I have no offer to communicate to Mr. Nelson at this time. I am a bit frustrated at this present time, Your Honor. I did try reaching out to the assistant prosecuting attorney to discuss these cases and have not received any word back. So I can certainly go into a breakout room with Mr. Nelson. However, again, I don't have any offer to communicate to him at this point, and it's, again, a little frustrating considering that this is set for the second pretrial conference at this point in time. So I just wanted the court to be aware of sort of what is happening right now, but absolutely, I can talk to Mr. Nelson in a breakout room, Your Honor, but it is very likely we will just be setting this on for another pretrial conference.
All right, well, let's do this. Have you had any contact with Ms. Curtis today?
I have not, Your Honor. I did try calling her and texting her at this point, and I have not heard anything back at this point, Your Honor.
All right, well, the court's going to recess then. I don't find any need to put you into a breakout room with Mr. Nelson yet until we are able to move forward. And I'm going to have my clerks try to get in contact with her.
Great, thank you. I really appreciate that, Your Honor.
You're welcome. Mr. Nelson, I see you. I'm glad you're here. You don't need to turn on your audio, but I am going to turn off your video camera because you're moving and it's distracting.
Hey, Mr. Nelson, if you can hear me, this is Kurt Oberholzer. You're unmuted. If you could just mute yourself so that there's no background noise, that would be appreciated. Thank you.
Mr. Overholzer,
Yes, Your Honor.
you just spoke with Ms. Harris Spencer, and upon review of her file, her driver's license is valid. She's here for arraignment on a DWLS, and so she is appropriately under the purview of the agreement that we have with the city attorney to reduce that charge. Could you come explain to her what that means?
Absolutely, I can do that, Your Honor. Let me meet with her right now.
Okay, thank you.
Thank you, Your Honor.
Mr. Craigsman, can you hear me? Can you come into the courtroom? Can you come in,
Absolutely.
please? Thank you. We are back on the record in the matter of Sheila Harris Spencer, case number 18-50901OT. You can come back up to the lectern, ma'am. All right. Ms. Harris Spencer, you are here for arraignment on a driving with your license suspended, revoked, or denied charge, but you do have a valid license now. And so the city is willing to reduce your misdemeanor offense to the civil infraction of allowing an unlicensed person to drive. Is it your choice today to take advantage of that offer and enter a plea of guilty or responsible to the civil infraction?
Yes, Your Honor.
All right. If you tender a plea today and I accept it, there will not be a trial of any kind on the original charge. Do you understand?
Yes, Your Honor.
All right. Did anyone threaten you or make you any promises in order to get you to plead guilty today?
No, Your Honor.
All right. As to the civil infraction of allowing an unlicensed person to drive, ma'am, how do you plead?
Guilty, Your Honor.
All right. Were you driving a vehicle in the city of Kentwood back on October 13th, 2018?
Yes, Your Honor.
And at that time, was your driver's license suspended, revoked, or denied?
Yes, Your Honor.
All right, I do find there is a sufficient factual basis to accept your guilty plea. I'm pleased that you have had your driver's license reinstated, especially if you have 2 children and 1 on the way, as you indicate that you do. It's practically impossible to be a functional adult or a parent without a valid driver's license. And so in this matter, I will assess fines and costs. They are $240.
That's the only one I have to pay.
Yes,
Can I pay that in full?
yes, I would be pleased if you would pay it in full. You can stop at the counter on your way out and make that payment.
I'm not coming back. Thank you.
All right, good luck, Ms. Harris Spencer. All right, the court is calling the case of the City of Kentwood versus Nawaf Muhammad Abdul Wahad, case number 21-50276OM. Sir, you can come right up to the lectern, please. So the City of Kentwood alleges that on or around March 1st of this year in the City of Kentwood, County of Kent, you committed the misdemeanor offense of providing false information to a police officer. That is a crime punishable by up to 90 days in jail, a fine of up to $500, court costs, and collateral consequences, such as if you are not a United States citizen, there may be immigration consequences. Do you understand the charge and the maximum potential penalties?
Yes, Your Honor.
And did you have an opportunity to speak with the MIDC attorney regarding your rights?
Yes, Your Honor.
As to the offense of providing false information to a police officer, how do you plead?
Not guilty.
All right, the court will enter a not guilty plea for you. We will schedule you a time to come back and meet with the city attorney. Is your address 3881 Camelot Drive Southeast?
Yes, Your Honor.
Is there an apartment number?
Townhouse.
Is there a townhouse number, or is the townhouse number 3881?
3881.
Okay. All right, that is where we will send the notice with the date and time and the instructions on how to come back and meet with the city attorney. I'm sorry? Oh, okay. If you want to step over to the side, we'll get you that notice generated today, actually. All right, thank you. You're all set. All right, the court is calling the case of the City of Kentwood versus Bishop Alexander, case number 21-50277OM. Sir, you can come up to the lectern, please. So the City of Kentwood alleges that on or around March 28th of this year in the City of Kentwood, County of Kent, you committed the offense of improper use of telecommunications, sometimes called malicious use of telecommunications service. So that is a misdemeanor offense. It is punishable by up to 90 days in jail and a fine of $500 plus collateral consequences. Sir, do you understand the charge and the maximum penalties? And did you have an opportunity to speak with one of the attorneys regarding your rights?
Yes.
As to the offense of malicious use of telecommunications, how do you plead? The court will enter a not guilty plea for you. We'll set you up with a date and time to meet with the city attorney for a pretrial conference. Is your address 11167th Street Northwest?
1166.
1166 7th Street,
Yes.
Grand Rapids 49504.
Yes.
All right, we will give you a notice today with the date and time. I know that you are going somewhere else after this, but you'll have it here. We'll send a notice out in the mail as well, and we'll see you back on that date. I need to enter some bond conditions, I believe. Sir, because I can see that you're being taken into custody at this time, I am going to set a $200 cash bond on this matter. That means you'll be getting credit for the days that you are in custody. If you are released from custody, you must show up on time for all court appearances. You may not leave the state of Michigan without the court's permission. You may not commit any crimes while out on bond. You must keep us notified of your address. Except through an attorney, you may have no contact with either Morgan Carter or Nicholas Drain. In person, in writing, by telephone, by text, by email, by social media, or by a third person. You may not possess or purchase any firearms or ammunition or dangerous weapons. And on the first day after your release, I will have you report to the probation department here, 62B District Court, and submit to test as directed by the probation officer or a police officer. You'll step over to the side, we'll get you that notice, or we'll get it to one of the officers and we'll go from there. Thank you. Yes, ma'am. All right, Mr. Nelson, it looks like we're waiting for Mr. Overholzer to come back on your matter with some new information, so just keep holding. It's okay, you don't
Can
need,
you say it again? You was breaking.
I'm sorry. What did you say?
I'm sorry. You were breaking up. I couldn't really hear you. I couldn't hear you.
Oh, well, I said that we're waiting on Mr. Overholzer to come back to determine what we need to do in your matter, so please keep holding. That's what I said.
Okay. Yes, ma'am. Thank you.
Mhm. All right, Mr. Robinson, I see you. You are represented by Mr. Overholzer, and so we'll need you to wait until we're able to call your case. I see someone appearing on my screen as Kara Perkins. Ma'am, what matter are you here on? You're muted. I still can't hear you. You are muted.
Yes,
Now?
hello?
Mr. Welford, hold on. Yes, Ms. Perkins, what matter are you here on?
Ronald Baker. I just met with the prosecutor, Angela Curtis, on this matter, and we've already had 2 pretrials, but I requested that we set it for a third so that my client can have some additional time to consider her offer. And she had, indicated that was okay, but she wanted to make sure that the court was okay with it.
Right, so I don't have that pretrial conference form. I'll wait until I get it. You did break up a little bit, but is your client available with you?
Yes, he is here with me.
Okay, all right, so I'll just have you hang tight until we get this figured out.
Thank you.
Appearing on my screen is iPhone. Ma'am, what is your name?
Alicia Orozco.
All right, and Ms. Orozco, you are also represented by Mr. Overholzer, and so we will have to wait a moment for you. So I'm going to rename you though.
Okay.
And Mr. Welford. Actually, Mr. Welford, I don't see you on my docket this afternoon. Oh, was he a walk-in? Okay,
You said what?
I found you. Mr. Overholzer, if you're there, do you need a breakout room with any of your clients at this time? All right, the court is calling the case of the state of Michigan versus Charles Welford, case number 20-30355 ST. You are Charles Welford.
Yes,
All right, I am Judge Sterkenburg. Sir, the state of Michigan alleges that on or around, December 2nd of 2020 in the city of Kent, County of Kent, you were operating a vehicle while your driver's license was suspended, revoked, or denied. That is a,
What it was, I thought my license was,
Okay. hold on. That is a misdemeanor. It is punishable by up to 93 days in jail, a fine of $500 plus court costs and collateral consequences, including Secretary of State penalties. You pled not guilty to that back in December of 2020 before my predecessor, Judge Kelly. You were set up with a number of dates to appear, and we have not seen you since February, or since January, it looks like. Sir, where have you been?
I've been doing nothing but working and trying to, I thought I was gonna be able to get on a payment plan and get my license back for my work, but they wouldn't let me do that. So I've been paying on my license and I'm just waiting to get those back. So
Well, you can't be on a payment plan with this court for this offense because you haven't been convicted of it yet. You are
You said
innocent.
what, ma'am? I couldn't hear you.
I said, you can't be on a payment plan for this offense in this court because you haven't been convicted of it. Sir, you're innocent unless proven guilty either by plea or beyond a reasonable doubt at a jury or bench trial. And so unless you are convicted and fines and costs assessed, you can't be on a payment plan for this offense. Do you have other tickets that you were working on paying off, like in other places?
Yes, 61st.
Okay, and this is the 62B District Court. So you were supposed to be here on February 1st at 1:30 in the afternoon, and you
I never got any mail of it.
All right. Judge Kelly, when he arraigned you, took your address down as 1212 Otilia Street Southeast, Apartment B,
Yes,
Grand Rapids, 49507. That's where you live?
yes.
Well, that's where we sent the notice. So is this the post office's fault?
You said what?
I said, is it the post office's fault? We sent it to the right address.
I really don't know because that's the right address. I can't tell you nothing, but I know I didn't get a letter in there for February 1st, or I would have showed up. Me and my mom, I would have had my mom drive me here. It was no problem. I would have showed up. But unfortunately, no, I don't have my license as right now.
All right, well, here's what we're gonna do. We're gonna give you another shot to get here. We're gonna set you up for a pretrial conference with the state prosecutor. We'll send notice of the date and time. Actually, can you generate that for me right now?
You said what, ma'am?
I'm gonna get you a date and I'm gonna tell you right now what the next date and time is that you need to appear for court. And then we're gonna mail you a copy. And I'm also gonna move you into a breakout room right now with one of my cashiers so you can give them an email address. So you'll have had actual notice, mail notice, and notice by email of the next date and time with the instructions on how to get back here and conduct a pretrial conference with the state prosecutor. Give me just a second and I'll get that date for you.
Okay.
It is June 8th at 2:30 in the afternoon.
All right.
We'll recall the bench warrant. No driving unless your license is valid.
Okay.
Evidence of all efforts that you are making to restore your driver's license to that pretrial conference with the state prosecutor. And I'm going to move you right now into a breakout room with somebody who can take your email address.
Okay.
Good luck, Mr. Welford. We'll see you back on June 8th. The court is calling the case of the state of Michigan versus Ronald Dale Baker, case number 21-30157 SM. Counsel, your appearance for the record.
Kara Perkins, on behalf of the defendant.
Thank you. And is your client in your office with you or on Zoom?
He's with me in my office.
All right. Are you able to swing your camera around so that I can see him?
Good afternoon, Your Honor.
Good afternoon. You are Ronald Dale Baker?
I am.
All right. Thank you. You can come back, Ms. Perkins. This matter was set for a pretrial conference this afternoon, and the court has received a pretrial conference statement indicating that Mr. Baker would like some more time to think over the offer here. The offer being extended is as charged, no objection to deferral under MCL 769-4A with credit for time served 3 days. Ms. Perkins, the allegations in this matter are not that old. They are back from April 14th. And so you've asked for another pretrial conference. It will be the last pretrial conference. We will allow one more adjournment. But if Mr. Baker chooses not to avail himself of an offer at that time, I will only accept pleas as charged with no sentencing recommendations, or we'll set the matter for a trial. Do you understand?
Does that mean that you wouldn't sentence him under the diversion program, or just you wouldn't take the?
No, I'm giving him I recognize this is his first criminal offense. He has no criminal history. So if he wants to take the time to think about it, and that's fine. So we'll do one more pretrial. He can accept the offer then, but if we don't have a resolution at the next matter, we'll set it for trial, or it will be as charged.
Very good. Thank you, Your Honor. We appreciate it.
Thank you. Have a nice day.
Thank you. You too.
All right, I see on my screen Japrecia Hicks. Ma'am, I don't have you on my docket. Is that your name? You're muted. I can't hear you.
Yes, ma'am.
All right, Ms. Hicks, why are you here? I don't see you on my docket. Do you have a case in this court?
Your Honor, if I may interject briefly, just to provide the court some information. Ms. Hicks is actually a victim on one of the cases, Trayvon Robinson, Your Honor.
Ah, okay. And you represent him, correct?
I do, Your Honor. I represent Mr. Robinson, Ms. Lewis, Mr. Nelson, and Ms. Orozco. All those clients are, they're all my clients, Your Honor, and I'm ready to meet with each of them right now, Your Honor.
All right, well, I will move Mr. Robinson into your breakout room first.
Perfect. Thank you, Your Honor.
All right, Mr. Robinson, watch your screen. You'll have an invitation to join a breakout room with your attorney. The rest of you, Mr. Oberholzer will be with you in turn. And who do you have with you?
I have Mr. Anton Howard.
Howard. Do you have a pretrial conference sheet?
So,
Could you provide that to my clerk, please?
I'm gonna go check with Mr. Oberholzer.
Hmm. The court is calling the case of the state of Michigan versus Antoine Lamont Howard, case number 21-30165 SM. Mr. Howard, you can come up and stand next to your attorney. All right, Mr. Kreisman, you have a motion for me?
I do, I would like to move at this time to represent my client here in court under Rule 8.120 of Michigan Court Rules. I have taken the oath that is required by this. I'm a third-year law student, and also I am in good academic standing with the law school.
And I will note that you have fantastic oversight in that Mr. Overholter is present in the building as well.
Absolutely.
Your motion is granted. This matter was scheduled for a pretrial conference this afternoon. Mr. Howard is charged with the offense of domestic violence, a 93-day misdemeanor. Is there an offer being extended by the state?
Yes, to my knowledge, the offer is as charged, but there will be no objection to charging this under 769.4A. This is Mr. Howard's first media offense, and we'll keep it off the record ground.
All right.
Keep it off his record ground.
Mr. Howard, did you discuss that plea with Mr. Kregsman?
Yes, Your Honor.
And is that what you would like to do today, accept that plea bargain?
Yes, Your Honor.
All right, if you tender a plea today and the court accepts it, there will not be a trial of any kind. Do you understand?
Yes, Your Honor.
And it is your voluntary choice to waive your right to a trial and all rights that go along with it in order to take advantage of this bargain?
Yes, Your Honor.
Has anyone threatened you or made you any promises above and beyond the plea bargain to get you to plead guilty?
No, Your Honor.
All right, then as to the offense of domestic violence, how do you plead? All right, I have to ask you some questions in order to establish a factual basis before I can accept your guilty plea. And so I will take you back to April 28th of this year. Were you at 2832 Christie Avenue in the city of Kentwood?
Yes, Your Honor.
And at that time, did you have some contact with one Janiyah Roberts Clay?
Yes,
Was that contact offensive to her? Was it against her will?
Yes,
All right, and is she someone with whom you have had a dating relationship?
Yes, Your Honor.
All right, I do find there's a sufficient factual basis to accept your guilty plea, and I will do so. Before I can sentence you, though, I need to know more about you and about this situation. And so I'm going to refer you to our probation department for a pre-sentence investigation. They will also reach out to the victim in this matter and ask for their input before you come back for sentencing. So I am going to have you stop at probation on your way out and set up that appointment. So you'll have an interview scheduled with them. And then once that has been conducted, we'll get this matter set for sentencing. All of your original bond conditions apply unless, is there a motion for bond on this matter?
I don't believe so.
All right, anything further?
No, Your Honor.
All right, then we're all set. Thank you. What is your name, sir? Mr. Zam?
Yeah.
All right. All right, the court is calling the case of the city of Kentwood versus Tang Sin Zam, case number 21-50130 OD. You can come right here to the lectern, sir. All right, Mr. Zam, the city of Kentwood charged you with operating while intoxicated. You entered a plea of guilty to that offense. We sent you for a substance abuse assessment. I note that you do not have counsel having waived that at arraignment. You did go to New Life Counseling Services and had an assessment done. Have you seen this report?
Yes.
All right. You're scheduled for sentencing this afternoon. Operating while intoxicated is punishable by up to 93 days in jail. The fine of up to a fine of up to $500. I have reviewed this substance abuse assessment and your criminal record. This is your first time being involved in the justice system, correct? All right. Do you have anything else that you would like me to know before I impose sentence in this matter? No? All right, well, tell me a little bit about yourself. Where are you working? You do, oh, at where? What farms?
Downtown.
Okay. How long have you been there?
6 years.
Are you a United States citizen?
Not yet.
And you have a 7-year-old son.
Son.
Is that correct?
Yeah.
All right, so when the court imposes a sentence, there are multiple different objectives. The first objective is punitive, and that is the punishment that you get for breaking the law. The second is restorative, and that is if there is any restitution being claimed, you can make the victim whole again. The last is rehabilitative. And that is to restore you to a position of normalcy. If you are drinking and driving, you don't have a normal relationship with alcohol. When you were arrested, it was after you were observed swerving, speeding, and almost hitting the curb. You blew a .15, which means you were well over the legal limit. Almost close enough for this to be charged as a high BAC, which is what Michigan calls our super drunk law. But it was charged as just an OWI. Which is still a significant and impactful situation for you because it's going to affect the status of your driver's license, right? And so the substance abuse assessment that you had done identified what they call a moderate alcohol use disorder, in that you maybe consume more over a period of time than you intend to, and again, make poor decisions after drinking. And so it is this court's goal to assist you in receiving some counseling, some therapy, to rehabilitate you back to a normal relationship with alcohol, so that we don't find you being a danger on the roads again, because it is dangerous to drink and drive. And so I am going to sentence you to 12 months probation with this court. I did see that you completed an alcohol highway safety class. Did you also do the victim impact panel? Okay. And you got your substance abuse assessment done. All right, the terms of your probation are as follows. You are not to violate the laws of any city, state, or federal government. You are not to leave the state without the court's permission. You are to make a truthful report to your probation officer monthly or more often as they require. You are to notify your probation officer immediately of any change in address or employment. You are not to possess or consume any alcohol, recreational marijuana, or drugs unless prescribed by a physician. You are not to misuse prescription drugs or be in the presence of anyone using illegal drugs. You will submit to alcohol and drug testing as directed by probation, and that requires a drug test fee. You will complete counseling as directed by probation, and I'm going to leave that up to them whether or not that includes going to a 12-step program like AA. You are not to purchase or possess any firearms or ammunition or dangerous weapons. You are to seek or maintain employment as directed and verify that with the probation officer. Sir, I am sentencing you to 24 hours of community service. Once you get the referral to community service, you must register for it within 2 business days. We don't want you waiting to the end of your probation to get this done. You are not to drive at any time without a valid license. And you are to pay fines and costs, which I will total for you now. Fines and costs total $1,185. You can stop at the counter on your way out to make payment or payment arrangements. And then stop at probation to schedule your first appointment. This is a final sentence of the court. If you disagree with the court's decision, you have 21 days to appeal it to the circuit court. You need the assistance of an attorney to do that and cannot afford one. You can request one from this court within 14 days. Do you have any questions for me? You're welcome. Stop at the counter, stop at probation. All right, Mr. Overholzer, who would you like to see next?
Your Honor, just for the record, well, I suppose, well, let me just start here, Your Honor. Mr. Robinson, I spoke with Mr. Robinson. I believe the court should be in receipt of a pretrial conference sheet indicating that that case will be dismissed. So I just wanted to state that for the record. I did have Mr. Robinson log off, given that it was a dismissal, Your Honor. So I suppose based on that, Ms. Hicks could leave as well here. And then as well as Ms. Dana Lewis, Your Honor, I believe the court also should have been in receipt of a pretrial conference for that case as well. That case is set to be dismissed as well per the assistant prosecuting attorney, Your Honor. And then I just have a final file here, Your Honor. I don't believe Ms. Curtis has sent over a pretrial conference sheet on Mr. Dante Nelson. However, based on my conversation with Ms. Curtis, that case should be a dismissal as well, Your Honor. I can certainly talk with each of the individuals. I just wanted to let the court know what was the status of each of those cases at this time.
I see a nollie for Mr. Robinson, and I see a nollie for Ms. Lewis.
Yeah, and I just...
What was the third individual?
The third individual, Your Honor, is Dante Nelson.
And that's going to be a dismissal too?
That is correct, Your Honor, based on my conversation with Ms. Curtis. And I did send her a text message because I didn't receive that pretrial conference yet, just to confirm that with Ms. Curtis. I suppose if Mr. Nelson wouldn't mind just hanging tight for a moment until we do hear back from Ms. Curtis. But yes, that should be a dismissal as well, Your Honor.
You are having an incredibly successful day for your clients.
Thank you, Your Honor.
And it looks like Ms. Lewis is being held on something else. That's correct?
That is correct, Your Honor. She does have a retail fraud first pending. However, she has pled to that already and is just awaiting sentencing on that case, Your Honor.
All right, Deputy, I do have a nollie for Ms. Lewis, and so she may go.
Okay.
Mr. Robinson is gone already. We'll wait for Mr. Nelson. We'll wait until we get a statement on that. I have
Then-
Cornell.
so-
What?
My apologies, Your Honor. I think we just started speaking at the same time. I was just going to say Ms. Orozco is my client as well, and I'm ready to meet with her at this time.
All right, well, how about I do this? I will put you into a breakout room with her. I was given an advice of rights form for Mr. Cornell, but I don't see him in my courtroom. Do you know where Mr. Cornell went?
I think he has an attorney.
Okay, all right, well, I guess we'll hold on that one and I will let you speak with Mr. Roscoe.
Great. Thank you, Your Honor.
Good afternoon, Ms. Mast.
Good afternoon, Your Honor.
The court is calling the case of the State of Michigan versus Alice Janes Gould, case number 21-30135 SD. You are Miss Alice Gould?
Yes.
All right, and Ms. Gould appears with her attorney, Ms. Megan Mast. This matter was scheduled for a pretrial conference this afternoon, and the court has been provided information that the state is offering to reduce the OWI charge to operating while visibly impaired, which is still a misdemeanor with the same attendant jail potential sentence, ma'am, of up to 93 days, but carries with it lesser fines and Secretary of State penalties. In exchange for your voluntary plea to operating while visibly impaired, they will dismiss the OWI. Is that the offer you discussed with your client, Ms. Mast?
It is, Your Honor.
And how are we going to proceed?
Ms. Gold would like to accept that offer.
All right, Ms. Gold, if you tender a plea today and the court accepts it, there will not be a trial of any kind. Do you understand?
Yes, I do.
And did you discuss your right to a trial and all of the attendant rights with your attorney?
Yes.
Is it your voluntary choice then to waive those rights and take advantage of the bargain being extended by the state?
Yes.
Did anyone threaten you or make you any promises above and beyond the plea bargain in order to get you to plead guilty?
No.
All right, then ma'am, as to the offense of operating while visibly impaired, how do you plead?
Guilty.
All right, ma'am, I'm going to take you back to April 4th of this year. Were you operating a vehicle in the city of Kentwood?
Yes.
And before you got in the car, had you consumed some kind of intoxicating substance?
Yes, I did.
I'm sorry, I have background noise. I did not hear you.
Yes, I did.
All right, and did that substance impair your ability to operate the motor vehicle?
Yes.
Ms. Mast, was there a blood or breath test in this matter?
There was I believe both. So we had a breath test, a PBT. Oh, I'm sorry, it was chemical rates. So I'm sorry, it was a data master and it was a 0.08. And then a second sample was given, let's see, about 15 minutes after that as well, and same result, 0.08.
All right. All right, I do find there is a sufficient factual basis to accept your plea to operating while visibly impaired. Do you agree, Ms. Mast?
I do, just one question, when you were operating, were you on a public roadway or a road that was open to the public? Yes. Okay, thank you.
Thank you, Ms. Mast.
You're welcome, Your Honor.
All right, ma'am, I will accept your guilty plea, but before I can sentence you, I have to know a little bit more about you and about your relationship to alcohol. And so I'm going to schedule you for a substance abuse assessment. I'm not going to schedule you. I'm going to refer you to one so that you can set that up. Ms. Mast can advise you of the agencies where we accept evaluations from. And in fact, our court will send a list and instructions to you so that you can get that done. We'll also schedule you for sentencing at another date, and you will come back after that evaluation has been completed. All of your bond conditions continue. Anything else on this matter, Ms. Mast?
Nothing further. Thank you, Your Honor.
All right, thank you. Thank you, Ms. Gould. Have a nice afternoon.
You too.
All right, Mr. Byrd, I know that you are represented by Mr. Oberholzer, and so we will have to wait until he is available to meet with you.
Okay.
Thank you.
Your Honor, sorry to interrupt. It looks like Mr. Bird is here, and he is a client of named Mr. Overholder, and I was going to take his, talk to him a bit about his pretrial conference.
Okay, yeah, I can set you up with that. Give me just a
Sorry about-
second, Mr. Krigsman.
Okay, sorry about that.
Let me tell Mr. Krigsman here. Mr. Krigsman, you should be able to use your same invitation to go back into the breakout room, and Mr. Bird is there.
Thank you.
You're welcome.
Your Honor, I'm not sure if you're able to hear me right now, but if I could have one more chance to talk to Mr. Byrd in the breakout room, I was just made aware that we may be proceeding straight to sentencing on this, and I just want to get some more background information on him and have a chance to talk to him.
Judge Sterkenburg's not in the courtroom. I can though, if you want to move back into the same breakout room that you talked to him. Deputy, can you move Mr. Byrd back to the breakout room that he was just in?
Yeah, we can do that.
Thank you.
Thank you.
No.
All right, Mr. Overholzer, I saw something fall into my email just now that says Orozco. So I have a pretrial conference sheet on that.
Yes, Your Honor. We will be entering a plea based on that offer, Your Honor, to the operating while intoxicated first offense.
Are we doing that today, or does it need to be set for a plea?
No, I think we're ready to proceed at this time, Your Honor.
No, Mr. Nelson, I thought that matter was going to be dismissed, but I don't know that I ever saw
I think,
form, and he's still here.
yes, I appreciate Mr. Nelson's patience. It looks like looks like Ms. Curtis just sent that over recently at 2:41. It doesn't look like, it looks like she had CC'd Ms. Lindsay as well as Ms. White on that.
No. That's fine.
Okay, I do have a nollie on this matter. And so, Mr. Nelson, if you can hear me, I know you've been waiting for quite some time.
Yes, ma'am.
It appears to this court that you may go. I am signing this order granting dismissal without prejudice in this matter.
Yes, ma'am.
Thank you, Your Honor.
Thank you. I appreciate you too, Kurt.
Absolutely, Mr. Nelson.
So I could just leave? How do I go about this?
Just hold on one second, Mr. Nelson. We're just finalizing, but you should be free to leave in just a second. Just hold on.
You are free to leave, Mr. Nelson, and so you can just leave meeting. There should be a button on the bottom right-hand side of your screen.
Okay, thank you.
You are very welcome. Mr. Craigsman met with Mr. Byrd, but I do not have a pretrial conference statement on that yet, so I don't know where we are going on that. So we'll go ahead and handle Ms. Orozco. What? Oh, you know what? I don't have a court reporter, so we can't do anything yet. Mr. Craigsman, will Mr. Byrd be a plea, or are we setting this for a trial or another pretrial?
We're entering a plea today, Your Honor.
Okay, well then I will wait for the conference on that. And then Mr. Morse, you are waiting to meet with Mr. Overholzer, correct?
Yes, that should be correct, Your Honor.
Well, how about I just go ahead and okay, now my court reporter's back. Mr. Morse, when we conclude, then I will move you into a breakout room with your attorney. I'm not sure if he can hear me or not.
Yes, I can hear you, Your Honor.
All right, thank you. All right, the court is calling the case of the state of Michigan versus Alicia Orozco, case number 21-30150 SD. You are Alicia Orozco?
Yes, Your Honor.
All right, and Ms. Orozco appears with her attorney, Mr. Kurt Overholzer. This matter was set for a pretrial conference, and the court has been provided information that indicates in exchange for your voluntary plea to the offense of operating while intoxicated first offense, the state will dismiss the high blood alcohol content charge, which is Michigan's super drunk law, ma'am. And so while it is still a misdemeanor, OWI first is punishable by less in terms of a potential maximum jail sentence and Secretary of State penalties. It is punishable by up to 93 days in jail and a fine of $500. Is this the offer that you discussed with your client, Mr. Overholzer?
It is, Your Honor. That is correct. And furthermore, Your Honor, I'd just like to state for the record that me and Ms. Orozco also discussed her trial rights. Specifically, Your Honor, that Ms. Orozco and I discussed that if she is to enter a guilty plea with regard to that aforementioned offer, Your Honor, I believe Ms. Orozco understands that she would be waiving her right to take the case to trial before a judge or jury. I did have a discussion with her informing her that by entering a guilty plea, she would be waiving that right. And Your Honor, I do believe with that understanding, Ms. Orozco still wishes to move forward and enter a guilty plea at this time.
All right, Ms. Orozco, is it your voluntary choice then to waive the rights that you discussed with Mr. Overholzer in order to take advantage of the benefit of being extended by the state?
Yes, Your Honor.
Did anyone threaten you or make any promises above and beyond what was stated in the plea bargain in order to get you to plead guilty?
No, Your Honor.
All right, then as to the offense of operating while intoxicated, first offense, how do you plead?
Guilty.
All right, ma'am, I will take you back to April 9th of this year. On that date and time, were you operating a vehicle in the city of Kentwood?
Yes.
And were you on a roadway that was public and open and accessible to motor vehicles?
Yes, Your Honor.
Before you operated that vehicle, had you consumed some kind of intoxicating substance like beer or alcohol?
Yes, Your Honor.
Did that substance impair your ability to operate the motor vehicle?
Yes, Your Honor.
Mr. Overholzer, was there a blood or breath test in this matter?
Your Honor, there was a data master breath test conducted in this matter, which did result in a 0.19 and a 0.19, so 2.19s, Your Honor.
All right, ma'am, do you have any reason to believe that those test results are incorrect?
I do not.
All right, I believe that suffices as a factual basis. Mr. Overholzer, do you agree?
Yes, Your Honor, I would agree.
All right, ma'am, I will accept your guilty plea, but before I sentence you, I will need to know more about you and about your relationship to alcohol. And so I'd like you to have a substance abuse assessment done. And so what we're going to do is have somebody from our court reach out to you with instructions on how you get that done. Is your address 327 Spencer Street Northeast in the city of Grand Rapids?
Yes, Your Honor.
All right, we'll send you information there on how to schedule a substance abuse assessment and when your sentencing date will be. Once the substance abuse assessment is completed, you'll come back for sentencing with Mr. Overholzer. All of your bond conditions continue intact until you are sentenced. Do you have any questions for me?
I do not.
All right, then you are all set. Thank you, ma'am.
Thank you, Your Honor.
Thank you, Kurt.
Absolutely. You're welcome, Mr. Roscoe. Have a great day. Give me a call with any
You as well.
questions.
Okay, thank you.
All right, the court is calling the case of the state of Michigan versus Justin Edward Bird, case number 21-30051ST. You are Mr. Bird?
Yes, ma'am.
All right, and Mr. Bird appears with his attorney, Mr. Kurt Overholzer, this afternoon. This matter was set for a pretrial conference, and the court has received information that in exchange for your voluntary plea of guilty to count 2, providing false information to a police officer, the state will dismiss count 1, operating a vehicle with your driver's license suspended, revoked, or denied. Is that the offer you discussed with your client, Mr. Overholzer?
It is, Your Honor. And just for the record, Your Honor, Mr. Kregsman did meet with Mr. Bird. So I believe Mr. Kregsman did discuss that offer with Mr. Bird.
All right, well, if you would like, Mr. Kregsman can motion in and we can have him complete this plea if that's what we are going to do, and you can meet with Mr. Morse.
That would be perfect, Your Honor. I have no objection to that.
All right, thank you, Mr. Kregsman. Just give me a moment to move Mr. Morse and Mr. Overholzer into a breakout room.
Absolutely.
All right. Mr. Kregsman is a third-year law student in an externship with the Kent County Office of the Defender. Mr. Byrd, he previously motioned this court for admittance to practice in a limited scope under Michigan Court Rule 8.120, which does allow law students to practice in a limited scope while under the supervision of of a practicing and licensed attorney in good standing. And Mr. Oberholzer is both of those, and he is here and present. And so do I have your permission to continue with this plea under Mr. Kriegsman's advice?
Yes, ma'am.
All right, Mr. Kriegsman, you are admitted to practice in this court today. And so it's my understanding that Mr. Byrd will be entering a plea to to the count of false information to a police officer. Is that the way you want to proceed today, Mr. Byrd?
Yes, ma'am.
All right. If you tender a plea today and the court accepts it, there will not be a trial of any kind. Do you understand?
Yes, ma'am.
And is it your voluntary choice then to waive your right to a trial and all other attendant rights in order to take advantage of this bargain being extended?
Yes, ma'am.
Did anyone threaten you or make you any promises in order to get you to plead guilty to this offense?
No. No, Your Honor.
Then as to the offense of providing false information to a police officer, a 90-day misdemeanor, sir, how do you plead?
Guilty.
All right, I'm going to take you back to January 28th of this year. On that date, were you in the city of Kentwood?
Yes, ma'am.
All right, what did you do that makes you guilty of the offense of providing false information to a police officer?
I provided a name that was not mine.
And did you know that the officer was acting in his official duties?
Yes, ma'am.
All right, I do find there's a sufficient factual basis and can accept your guilty plea. Mr. Byrd, are you being held on something else?
Yes, ma'am. Revoking my probation through your court, actually.
You're
Ma'am.
serving a sentence for me?
Yes, ma'am.
That's likely why I gave you this $100 bond. All right, sir, I will accept your guilty plea. Mr. Kriegsman, is there any objection to proceeding to sentence today?
No, I believe we're prepared for that, Your Honor.
All right, then I'll hear your allocution.
Thank you, Your Honor. I've had the brief but fortunate time to speak with Mr. Byrd, and while he is currently in jail for another charge, it seems like he is taking responsibility for his life and looking for a way to move forward and avoid the circumstances that have got him where he is. He's no longer in contact with the woman he was with on the night of his current charge. He is working at his own business with a partner doing roofing, and also staying with that coworker so he has a place to live, while on the weekends he lives with his mother so that he can have contact with his 14-year-old daughter. It seems as though Mr. Byrd understands the situation he got himself into and is willing to take responsibility and do his best to avoid situations like this, and is moving in a positive direction for his life.
All right, thank you, Mr. Kriegsman. Mr. Byrd, you don't have any other active criminal charges, correct?
No, ma'am.
Is there anything else that you would like me to consider before I post sentence?
No, Your Honor.
I'm gonna look up your other matter real quick. Unless you can do it more quickly for me. Will you look and tell me what the sentence was in his probation? Will you look in JMS, I don't have it pulled up, and tell me what the sentence was in his probation revocation?
Yeah, he's got here stay. So, pled guilty, 30 days jail, paid $565 or served 14 additional days.
And that was, that's on
The third.
the third of this, okay.
What's your name? It should be rolling through now.
All right, Mr. Byrd, you are serving a 30-day sentence for me with a pay and stay on fines and costs. For an offense of this nature, the law presumes that an acceptable sentence can be fashioned out of fines, costs, and community service. I'm not going to sentence you to any community service at this time. I'm going to assess fines and cost only. Give me a moment to do so.
She's not realizing you on there?
All right, so fines and costs in this matter are assessed at $525. They are due immediately. If you are unable to pay them, then you will do an additional 11 days in jail, and you will be there anyway, sir, and so that is a pay or stay. That is the final sentence of the court. If you disagree with this court's decision, you have 21 days to appeal it to the circuit court. Oh, you know what, sir, just for the record, I did also give you 9 days jail credit for 9 days served because you did 9 days on this for me previously. If you need the assistance of an attorney to appeal your matter to the circuit court, you may request one within 14 days. Any questions?
So this the 11 days I was just given, that runs concurrent with the time that I'm already doing?
Correct.
Thank you.
Yes, you're welcome. All right, thank you. All right, Mr. Morse. Mr. Bird's is back, but I don't have anything on that just yet. And so we're going to handle at least one matter here in the courtroom. You're not here on Thomas Bosher also, are you, Mr. Watkins?
No, you're not.
All right, the court is calling the case of the state of Michigan versus Aaron Anthony Gomez, case number 21-30112SM.
Your Honor,
Yes, you may. Thank you. All right, you are Mr. Gomez?
Yes, ma'am.
All right, Mr. Gomez appears with his attorney, Mr. Daniel Watkins, this afternoon. This matter was set for a pretrial conference. There were 3 counts of assault or assault and battery pending in this matter, and the court has received information that indicates in exchange for your voluntary plea to counts 1 and 3, count 2 will be dismissed, and there will be no objection to sentencing under the Holmes Youthful Training Act. Is that correct, Mr. Watkins?
That is correct, Your Honor.
All right, and how are we proceeding today?
Your Honor, Mr. Gomez wishes to avail himself of that offer, the elected rights of the trial and enter a plea.
All right, is that what you want to do, Mr. Gomez?
Yes, ma'am.
If you tender a plea today and the court accepts it, there will not be a trial of any kind. Do you understand?
Yes, ma'am.
Is it your voluntary choice then to waive all the rights you discussed with Mr. Watkins in order to take advantage of the bargain being extended by the state?
Yes, ma'am.
Did anyone threaten you or make you any promises above and beyond the plea bargain to get you to plead guilty?
No.
All right, then as to count 1, assault and battery alleged against one Arnold Mazarigos Gramajo, how do you plead? And as to count 3, assault or assault and battery upon one Kevin Estuardo Mazarejos, how do you plead? All right, before I can accept your guilty plea, I'm going to have your attorney ask you some questions so that I can establish a factual basis. Are you prepared to do that, Mr. Watkins?
Yes, sir. Mr. Gomez, you recall on March 7th, 2021, being at the soccer spot or indoor soccer facility in the city of Kentwood over on 32nd Street.
Yes.
And while at that location, you were playing a soccer game, correct?
Yes.
And did you on that occasion, did you get into an argument with an Arnold Mazariegos Gramajo?
Yes.
In fact, did you punch Mr. Mazariegos Gramajo?
Yes, I did.
And was that in self-defense?
I don't believe so.
Okay. Then, my understanding is that that fight was broken up on the field, correct?
Yes.
And did you, while still at that location, try to leave the field and get into a confrontation with a Kevin Estuardo Mazariegos?
Yes.
And did you have to force your way past him?
Yes, I did.
And in doing so, did you assault him?
Yes.
By pushing him or shoving him?
Yes.
Okay, and that was not in self-defense, was it?
It was.
No, that one, to force your way past him, you were not defending yourself.
Oh, no.
And that also was on March 7th, 2021.
Yes.
All right, and for the record, then this 3701 32nd Street, the soccer spot, I don't know the name of that location, but I know what you're talking about. That is in the city of Kentwood, correct?
Yes.
It is the MSP Sports Complex. It used to be called this.
Did it? Okay, then all right, then my memory is good. All right. Sir, I do find a sufficient factual basis to accept your plea on these 2 counts. And I'm going to refer you to a pre-sentence investigation. I want some more information about this incident and to give the victims opportunity to give insight before you are sentenced. So I'm going to have you stop at the probation department on your way out to schedule that appointment. And then you will come back for sentencing at another date with Mr. Watkins. All of the conditions of your bond that I set previously remain in place until you are sentenced. Do you have any questions for me?
No, Your Honor.
Anything further, Mr. Watkins?
Nothing further, thank you.
All right, thank you. Have a nice afternoon. All right, what is your name, sir? One more time, your last name. All right, Mr. Ficarini, I'll be with you in just one moment, okay? Is here for sentencing. All right, Mr. Overholzer, you represent Mr. Morse, and I have one Sherry Morse coming in.
Yes, Your Honor. We were, well, I suppose I'll just wait till the court calls the case.
Thank you. All right, the court is calling the case of the state of Michigan versus Matthew Harrison Morse, case number 21-30152SM. Sir, you are Matthew Morse?
Yes, ma'am.
All right, Mr. Morse appears with his attorney, Mr. Kurt Oberholzer, this afternoon. This matter was scheduled for a pretrial conference. The court has received information that in exchange for your voluntary plea, sir, to the offense of domestic violence, first offense, the state will dismiss the original charge, domestic violence, second offense. Is that the offer you discussed with your client, Mr. Overholzer?
It is, Your Honor. And at this time, we will be rejecting that offer, Your Honor, and respectfully setting this matter on for a jury trial at this time, Your Honor.
All right. Mr. Morse, certainly that is your right. I cannot guarantee for you how long it will be before we get to a jury trial. We are daily making steps towards having a more fluid situation in the court as it relates to COVID-19, but we will get you docketed and on that list for a jury trial. And then I do note that someone named Sherry Morse has joined, and I believe that she is the victim alleged in this matter. And so, Mr. Overholzer, is there something further?
Yes, Your Honor. Respectfully, at this time, we would like to submit a motion to the court for the court to consider amending the bond conditions with specific regard to the no contact order that this court put in place, Your Honor. It is my understanding that the victim in this case, Sherry Morse, potentially would like to see that no contact order lifted at this time, Your Honor. I'll leave it to Ms. Morse to address that with the court. But again, Your Honor, we are respectfully moving at this time to have the court consider potentially amending bond conditions as to allow the Mr. Morse to have contact with Sherry Morse, Your Honor.
All right, Ms. Morse, I'll hear your comments in just one moment. You can go ahead and unmute yourself, but I want to take a look at something else. All right. Mr. Overholzer, before I hear Ms. Morse's comments, the prior conviction here appears to be deferred under 4A, but it was out of this court. Can you tell me if this is the same victim?
I do, but to my understanding, Your Honor, I do believe it is the same victim. Yes.
Is that correct, Mr. Morse?
Yes.
All right. They have you as Miss Zeilman in the affidavit of probable cause. Are you Miss Zeilman? I'm sorry, Miss Zeilman or Miss Morse, ma'am?
Morse. We were married in April.
Of this year?
Yes.
All right. And you believe it's appropriate for this court to lift the no contact order in this matter?
Yes.
All right. Why?
Well, he's my husband, and it was just a bad night, and I believe in him. And I think that he's changed, and I think that he'll be better.
So if I lift this bond condition, that is the no contact order, how can I be certain that you will be safe, Miss Morse?
Well, he promises me,
Mm-hmm.
and I believe him.
You in JMS, can you look up his other case? Because I'm assuming that he is on probation then. Judge Kelly put him on probation under 4A. And what are the terms of his probation? You don't have any, do you have like the duration?
Looks like it's 12 months probation with Maxwell. Shall not possess, purchase a firearm, should attend 12-step meetings, complete counseling, possess or consume alcohol, other drugs unless prescribed, submit to alcohol, drug testing, seek and maintain employment shall pay restitution as determined by the court, shall pay fines and costs of 5.5 or serve 22 days in jail.
But there was no contact order. Judge Kelly lifted the no contact order in the prior case. Is that correct, Mr.
That's
Morse?
correct. Yes, that's correct.
So ma'am, he promises you, but he also promised this court in November of 2020 that he would not commit any crimes while out on bond. And he is alleged to have committed another domestic violence offense. And so I didn't hear that case. It was in my court, but that was Judge Kelly, and he retired at the end of the year. And whatever the nature of the conduct in that, it was sufficient at that time for you to believe that it wasn't something that would continue and that you went ahead and married this man, correct? Have I got the timeline right, Ms. Morse? I'm not going to lift this no contact order, Mr. Morse. I'm sure it is very difficult to be separated from your spouse, both of you. I recognize that situation, but I have great concerns about public safety. And until this matter is resolved, I'm not willing to lift the no contact order. It's not even been, it's barely been 6 months since the sentencing on the first. And while you are innocent unless proven guilty, sir, the allegations in the affidavit of probable cause are those that I can take into consideration when setting bond conditions. Your motion is respectfully denied, Mr. Oberholzer.
Thank you, Your Honor.
Code for administrator.
Thank you for calling Number 9 on solutions. So this call may be monitored for training and quality assurance purposes. My name is Bahia. ID number 1103.444. How may I help you? You know what? I just asked for mercy and forgiveness.
Well, sir, it's not for me to give forgiveness.
Yo, mimi mwenye anapeana hiyo msamaha.
My job is to make sure that justice is administered.
Kazi yangu mimi ni kuhakikisha kwamba haki inapatikana.
But I appreciate that you are taking responsibility for your actions.
Na kubali kwamba wewe unachukua hatua kutokana kwa jibu ya dhambi yenye wewe umefanya.
This was a very dangerous situation.
Hii ilikuwa ni hali ya hatari kabisa sana.
You crashed your car and you had a blood alcohol content of 0.16.
Gari yako ilibomoka na pia damu yako pombe ilikuwa 9.16.
You hit another car.
Uligonga gari nyingine.
You could have hit a person.
Uligonga binadamu.
There could have been injuries.
Ungekuwa na jeraha.
It could have been a lot worse.
Ingekuwa mbaya zaidi.
Sir, do you have any other criminal matters that are pending?
Kwa dhambi nyingine ulizofanya ya uhalifu bado inakungoja? No.
Sir, I'm looking at your criminal record, and it looks as though you were previously convicted of operating a vehicle with a high blood alcohol content back in 2018. Is that correct?
Mwaka ya 2018 naona kwa rekodi yako ya uhalifu na inaonyesha kwamba ulipatikana na dhambi ya kuendesha gari na hali ya pombe kwa damu kwa juu na ulihukumiwa. Ni kweli? Yes, I remember that.
So you already had a drinking and driving offense, and you didn't learn your lesson?
Ushakuwa na hii dhambi ya kuendesha gari kama unakunywa pombe haujajifunza mambo yoyote?
Siku nilisema kwamba natoka ilikuwa nyumbani wakijua simu kama baba anauza sana Afrika, kwa hiyo nisaidie kidogo matibabu ya hospitali. Sasa ile hali ilikuwa ni mshtuko, ilikuwa mpaka mshtuko, na nikaja hivyo sasa ile benki kuchukua yale mimi nitumie baba mzazi kule aenda katibu.
I did learn my lesson, but that day what happened was that I received a phone call that my dad was very sick in Africa. I was in shock. I had to rush to the bank to get the money sent to me so that he can go for treatment.
Well, I'm sorry to hear about your dad. I've lost both my parents. Both of them are gone. And so I understand how difficult it can be when a parent is ill.
Naelewa kwanza na kusema pole kwenye hayo, lakini naelewa vizuri sana kama mzazi amekuwa kwa mgonjwa, kwa sababu mimi ndio nimepoteza wazazi wangu wote wawili. Najua hiyo ni ngumu sana.
But when you got picked up for this drinking and driving, did it help your dad?
Alafu vile ulienda kuendesha gari kama unakunywa pombe, hiyo inasaidia mama yako? No, they did not, and I apologize for them because I was just in shock.
Did this help your shock?
Alafu nisaidia mshtuko yako vile ulifanya nini? That's why I am apologizing. It had already happened and I will not repeat this again.
I wasn't there, but I suspect you said that the first time.
Mimi sikukuwa kule na wewe, lakini mara kwanza ulisema nini?
Do you speak any English, sir?
Unaongea Kiingereza na basi?
Kidogo sana, si bado ndio kutoka Afrika, yani nasikia kidogo kwa mbali.
Just a little bit. I'm new from Africa, so just a little bit of English.
How long have you been in this country?
Uko hapa nchi miaka mingapi?
Uko na miaka mingi.
4.
4 years?
Uko hapa miaka minne? Yes.
Sir, when I sentence people, I have several objectives in mind, goals.
Nikipata mtu sentensi lolote mimi na kuanga na lengo kwa kichakani.
The first is punishment for breaking the law.
Ya kwanza ni kupatia adabu kwa kuvunja sheria.
The second is restorative, and at this time, I don't know that anyone is seeking for you to pay them back for the damage that was done to their car.
Na ile nyingine ni malipo. Kwa sasa hivi sioni kama kuna mtu yoyote anaomba malipo yoyote ya uharibifu uliotokea kwa gari yao.
But I will reserve restitution in this matter.
Kwenye hii sasa hii amesema kwamba ataihifadhi.
And the last is rehabilitation.
Na ile ya mwisho itakuwa ni ukarabati ama ushauri.
Rehabilitation brings you back to normal. That's what it's supposed to do.
Ukarabati inakurudisha kwa njia ya kawaida. Hiyo ndio inafaa kufanya.
And so a goal of mine for you is to bring you back to a normal relationship with alcohol, because this is not normal.
Sasa lengo yangu mimi ni kuweka wewe na songe mawasiliano ama uhusiano mazuri, kwa sababu hii sio uhusiano ya kawaida.
I don't know why this was charged as a first offense, because it should have been charged as a second. And the penalties available should be much greater.
Sijui kwa sababu gani wamesema hii dhambi yako ya kwanza ilikuwa ni dhambi ya pili, na dhambi ya pili adabu yako ama penalti ile unapigwa itakuwa ni kali kubwa.
But I can sentence you up to 93 days in jail for this offense.
Kwenye hii dhambi nitakupiga kwa siku 93 kwa jela.
But I think what would help you more is counseling and treatment.
Hivyo itakusaidia wewe zaidi. Nikupatia ushauri na matibabu.
I'm going to place you on probation with this court for 9 months.
Na pia nitakuweka katika ile njia ya kizuizi kwa miezi 6.
The terms of your probation are as follows.
Na pia lengo la kusema ama shughuli ya kukua na hii kizuizi itakuwa ni safi kabisa.
You are not to violate the laws of any city, state, or federal government.
Haufai kuvunja sheria yoyote ya kijiji, ya state ama ya serikali ya federali.
You are not to leave the state of Michigan without the court's permission.
Haukubaliwi kuondoka kutoka state ya Michigan bila kuomba kodi.
You are to make a truthful report to your probation officer monthly or more often if they require it.
Ofisa yako ya kizuizi pia unafaa kumjulisha, na ofisa yako ya msamaha unafaa kumjulisha kila mwezi ama vinanavyohitajika, anahitaji maneno ya ukweli.
and you are to notify them of any change in address or employment status.
na pia unamjulisha kama address yako imebadilika na nyumbani ama kazi yako pia imebadilika.
You are not to possess or consume any alcohol, marijuana, or other drugs.
Haukubaliwi kukua wala kukunywa pombe, dawa ya kulevya, bangi ama dawa ya kulevya aina yoyote.
You are not to misuse prescription drugs.
Na hauruhusiwi kutumia ama kutumia kwa njia mbaya ama hali ya ziada dawa yenye zinaandikwa na mganga.
You are not to be in the presence of anyone using illegal drugs.
Na haufai kukuwa karibu na mtu mwenye anatumia dawa ya kulevya.
You are to submit to alcohol and drug testing and pay the required fee.
Na unafaa kujipatiana ama kujielekezea kulingana na iliyowasilishwa kwa matibabu ama kwa vipimo vya pombe ama dawa ya kulevya, na utakuwa unalipa hiyo vipimo.
You are to complete or continue counseling as directed by your probation officer.
Kwa ofisa wako ya majaribio ndio mwenye atakuwa anakupatia utaratibu kwa kuendelea kushauriwa na kumaliza hiyo utaratibu wa kushauriwa.
You are not to purchase or possess any firearms, ammunition, or dangerous weapons.
Haukubaliwi kununua silaha, bunduki ama silaha ya aina yoyote ya hatari.
You are to seek or maintain employment and verify that with your probation officer.
Na unaomba kazi na kuendelea kukuwa na kazi yako na unauliza taarifa za ziada ofisa wa majaribio.
You are to pay fines and costs, which I am adding up now.
Na pia unapigwa fine na malipo na sasa napiga hesabu.
Fines and costs in this matter total $1,185.
Faini na pesa za kulipishwa ni 1,185.
And sir, I am sentencing you to 15 days in jail, credit for 1 day served. You are to contact this court on the next business day after your release to make arrangements for your probation and to set up a payment plan.
Bwana, nitakuhukumu kufungwa siku 15 kwa siku moja kubaki hapa, na siku yenye utaachiliwa siku ya pili, kama ni wakati wa biashara, unawasiliana na hii kotini, watakuwa watakuunganisha na ofisa ya majaribio na pia malipo yenye inayohitajiwa kulipa.
This is a final sentence of the court. If you disagree with this court's decision, you have 21 days to appeal it to the circuit court.
Na kwamba kama hizo sasa mwisho yenye tumeamua uamuzi kwa siku 20 hizo, matokeo yetu siku 21 ndio unaweza kulalamika kwenye hii kotini ya circuit court.
You can request an attorney to help you with an appeal. You have 14 days to do that.
Ukitaka kulalamika kwa siku 14 na unaomba mwanasheria kusaidie. I would pay the penalties, but I have to find an attorney to help me with it.
So you were offered a court-appointed attorney.
Washakupatia kotini, walikuhakikishia mwanasheria.
You waived your right to a court-appointed attorney on March 30th.
Mwezi wa 3 tarehe 20 ulikataa hiyo mwanasheria.
You did that with the assistance of an interpreter.
Ulikataa na pamoja na mfasiri.
And you pled guilty.
Na ukasema nimekubali dhambi yangu.
You are certainly welcome to request an attorney to help you appeal this sentence.
unaweza tena kujiagizia wanasheria kuweza kukulalamikia tena kujaza malalamiko.
I will have an application for court-appointed attorney provided to you for that purpose. You can fill it out and submit it to this court within 14 days.
Anasema kupata application ya kujaza na kuanza hiyo malalamiko ama kupata rufaa na mwanasheria kotini watakuandikishia katika siku 14.
But you could have killed someone, sir.
Bwana, ungeua mtu.
The penalty is more than just fines and costs this time.
Amesema kwenye hii wakati kuhukumiwa yako ni kushinda malipo ya hiyo penalty na unapigwa pamoja na kuhukumiwa.
Nasema hivi na sasa namba nisikilize basi kwanza nilipokuwa mimi malipo moja wakuja kunisaidia basi kwa sababu nisaidia kubwa kunyumba na hivi watoto wanapohangaika kuwaweka kwa masomo na mimi kazi ndio hivyo kutoka kwa kazi. Kwa hiyo wanipe muda tu kafanye lawyer na sitarudia tena na kama nikurudia hiyo nani hii kama tunasema hata nalipa basi angalau hiyo takuja tena kuongezea kulipa hiyo nilipe kwanza na nipoteza kujitolea basi kwa sababu naona kukaa hapa ndani itaniasi sana wakati watoto watahangaika sana.
Yeah, I say that I hear you, but I also apologize, and also I have a large family that kids won't suffer. They're supposed to get them to school, also my job. I will pay the penalty and give me some time so that I can find also a lawyer that can represent me.
The penalty is 15 days in jail, credit for 1 day served. You're all set, sir.
Amesema amemalizana. Amesema umehukumiwa siku 15, siku moja ndo utafungwa.
Kwanza ni watoto watahangaika watoto